All right, we're all situated. Welcome. Thank you for joining us today. Just give us another minute. We've got our attendees are still coming in, and I'm just waiting for all the live stuff to queue up and be running. Looks like it is. Um, Thanks for joining us. Today we're going to talk about mitigating risks post-pandemic. We're on Zoom webinar, so a couple things that I want to say before we jump in. It broadcasted. Ooh, I'm getting my audio back. I think that was maybe coming through Fred. All right, so we're using Zoom. We're using Zoom webinar. If you have questions, please use the Q&A button at the bottom. Type in your question for Brad or the rest of the team, and we'll be sure and impose the question for Brad. I'm going to walk through a couple of things. First, I want to introduce our team. We are ConnectStrat. We are EOS implementers and strategic coaches for the IT services community at large. And I myself am one of the strategic coaches. I started my MSP in 1995, sold it in 2016, so a nice 21 years doing that. I've been working with leadership teams for several years, and I'm currently also the CEO of both Smileback and TimeZest. I'll pass it on to Brett, if you could introduce yourself.
Yes, my name is Brett Jaffe. I'm also one of the strategic coaches at ConnectStrat. Very much like Jameson, I was in the IT space with an MSP for over 20 years. Migrated to the vendor space, and now, in addition to ConnectStrat, I'm also CEO of Audit.
Thanks, Jason. Oh, you're on mute, sir.
Yep, sorry about that. Yep, my name is Jason Knight. I'm also a strategic coach, a professional EOS implementer in the Houston area. I cover Texas for mostly the MSP and IT services space. I've been in the IT services world for almost 3 decades now, having started and grown and sold a number of companies, the last one in 2014. I now continue to work with business owners and leadership teams to help them get the most out of their business, mainly through EOS.
Thanks, Fred.
Hi, I'm Fred Genshin. I'm also a strategic coach. I am a professional EOS implementer and a certified life plan facilitator. And I started my career 27 years ago in the IT industry as a sales and marketing leader. Thoroughly enjoyed that, but really enjoyed working with technology entrepreneurs while I was doing that. So like late last year, I decided to start my own consulting business focused on technology entrepreneurs.
All right, thanks all. I'm going to introduce our guest speaker today, Brad Gross. We shared a wonderful dinner up in, what was it, SeaTac.
Yeah, Seattle, right?
Yeah, south of Seattle. We were at a user group. I used to live up there. I've moved to the sunny desert. Wanted to be more like Fred. And now I'm in Vegas, but yeah, that's right. It was Seattle. You remember? It was random. It was in a little like a gas station parking lot place.
It was crazy. It was crazy, but it was amazing food.
So, sir, please introduce yourself.
So glad to be here. Brad Gross. For those of you who have not heard me speak or seen me before, I have a law firm that concentrates in representing MSPs, TSPs, solution providers globally. We represent more MSPs and TSPs than all law firms combined. We're probably well over 1,000 at this point. Been doing it for a while, about 20 years. So looking forward to answering the questions that anyone has. Just throw them up on the screen there, and we'll get to as many as we can.
Great, thank you. So I'm just going to preface that this is the first time we've leveraged our new platform. We're leveraging an application called Mural, and we're leveraging that now in our consulting practice. We decided to try it within a webinar. So in the past, we'd used 90.io, but we thought this was really going to be nicely conducive to a conversation. So we've been collecting questions from folks, and we will tackle these questions one at a time. And in true IDS form, we'll treat them as an issue, move them to the discuss side, have Brad talk about it. We'll have Brett scribe and make sure we're keeping up. Again, if you have questions, just post them. We'll add them right into the questions and issues list, so we make sure we capture them for Brad. So I'm going to start just right with some jumping into employees who refuse to go on. That's the second one from the top right, Brett. What if I have employees who refuse to go on site due to at-risk environments? So I'm hearing this from people, owners don't know what to do. What about employees who don't want to come back to work? How do you deal with that?
Well, first of all, a couple of things that are in that question. It's not just related to an employee who's refusing to work. The question talks about at risk, right, to an at-risk site. So the first, I guess, issue that you have to tackle is, what is an at-risk site? These days, pretty much any place where there is somebody else could be a theoretical at-risk site, but at-risk sites do not divest an employer's ability to tell an employee, do your job, because everywhere is an at-risk site right now, other than maybe your own living room. So the idea is that while an employer is not supposed to send an employee into a location or a situation that has a substantial risk of physical harm, right, injury to health and so on, I cannot see, and I have not heard of any circumstance in which requiring an employee to go to a particular location in and of itself is, quote, at risk, especially if you're going to provide them, and you should with PPE, right, the masks, the gloves, and so on. You can absolutely require the employee to do his or her job, assuming that there is no pre-existing condition, right, assuming the employee doesn't have something that puts him at a higher risk, and that's a different issue. That's a different discussion. But generally speaking, a healthy person who says, I'm a little scared to go into that location, well, they're going to have to get over it because they don't really have the right to refuse.
Well, that becomes, that I think walks pretty quickly right into another question I think that we'd already framed over here, but if we don't, I'm just going to ask it while I look around.
Okay.
What do you do if an employee does refuse to come into that environment? Like, what do you do as the owner of a business when an employee refuses to, it says they're frightened or whatever? What are your rights? What do you do?
Right. Well, I'll tell you, again, two issues arising from that. If the employee refuses to come in because he is just nervous, he has to get over it. I mean, that's the bottom line. He has to get over it. If for some reason the employee had a legitimate excuse that's covered under, let's say, the ADA, Family Medical Leave Act, like he has, I don't know, a diminished health capacity, maybe he has an immunodeficiency or something like that, then that's a discussion you want to have with the employee to see if a reasonable accommodation can be made. But assuming, again, that's not the scenario that you're dealing with, it's just your average healthy person simply saying, I'm nervous, well, the person either has to get over it or find another job. That's sort of the way it is. And if the person does have a problem, like an immunodeficiency, a COPD, something like that, the employee has to bring that to your attention as an employer. The employee has to bring that to your attention. You don't have to guess, you don't have to assume. The employee doesn't bring it to your attention, you can assume that person is a healthy person and just simply refusing to do the job.
And that's really interesting and helpful. I actually have somebody in the audience who'd like to ask a question. I'm going to ask you to jump in. Kevin, I think Eiler, if I have it right, I'm going to see if they can come off mute. Just ask you to come off mute if you don't mind and ask Brad your question. Just give him a second to come off mute.
Working the technology, we're working the technology.
Well, I'm eating lunch while we're having this meeting, and so I had a mouthful of food.
All right. I'll make you feel better. I will drink my water while you ask.
All right, I'm good. So what if, and you kind of mentioned, answered this at the end with the legitimate excuse, but what if I have an employee has a family member that is at risk, say a heart disease, or elderly, someone they're concerned about.
Right.
And I've had that situation about this person wanting to stay more remote, more at home during this time. And just how should I respond to that?
So, I'll tell you this, and I'm looking at your questions on, I have multiple screens here. All right, so the question can be framed as, if the employee himself is not ill, right, doesn't have COVID, is an otherwise healthy person, but has somebody at his or her house, right, that might have a vulnerability, can the employee claim a disability or ask for a reasonable accommodation? Under the ADA, the answer is no. The ADA only covers the employee's disabilities, the employee's accommodations. It doesn't cover the people that the employee is exposed to. And if you think about it, while it might sound a little bit, cold and very bottom line, like, where's the heart in all of this? I guess that the logic behind it is that, where do you draw the line, right? I'm not immunodeficient, either is my wife, but she often will go to her friend's house where you could keep drawing it farther and farther to the point where it makes no sense. So right now, the way the law is, as of today, an employee who says, I have someone at home and I can't risk getting sick, well, that's a choice the employee is going to have to make under the law. Now, as a business owner, I'm not suggesting that you simply say, forget it, you're fired, or, deal with it. I think you should be dealing with your employees. I think that these situations are going to come up from time to time, and the building of the goodwill, if there can be a reasonable accommodation, maybe you should consider making it. But if you're asking me strictly legally, does the ADA require you to make an accommodation in that case? The answer is no, it doesn't.
Okay, good, thank you.
Yeah.
Kevin, thanks for
Back to
joining
your
us.
lunch.
Appreciate it.
Thanks.
All right. So moving forward, I'm going to jump into another question. Very kind of similar, but one of my concerns, I'm just going to bring it right on over here for Brett. One of my concerns is an employee contracting COVID-19 outside the workplace could have an effect on my operations. How would you handle this if it happens?
Well, obviously, there's the legal end and then there's the business end, which you guys could address as well as anybody. A case in which an employee contracts it outside and it has an effect on the operations, I guess you have to figure out what the effect would be. Well, first of all, if it's somebody who's sick, you exclude that person. That's one. Okay, that's a ground ball. Everyone, I think, would understand and know that. Can you announce to your people that Joe, let's say, has COVID, so he's not coming in? No, you shouldn't expose the name of the person to the workplace. That's another thing to keep in mind. Before that person comes back, you can require a few things, and you probably should. You can require a doctor's note, right, for fitness to serve, fitness to fulfill the job. You can require that. You could even take the temperature of people who are coming into the workplace if you have a reason to believe that they either had the COVID-19 or that they are susceptible to it. And these days, because it's a pandemic and it's a direct threat, those are the buzz terms under the ADA, it's a direct threat, you could actually take the temperature of everyone who walks into your workplace. But circling around, I would exclude the person, I would get a doctor's note before the person came back, and I would not announce to the staff the name and identity of the person who is ill, because that would probably violate privacy laws.
So I kind of a little add-on question to that. I'd heard somebody say at one point, but they weren't an esteemed attorney, that don't play doctor. I've heard that word a couple times. Is there? I mean, I hear what you're saying. Kind of, you don't want to violate HIPAA and privacy laws and that kind of thing. But you are advocating that you could take the temperature, you could do some things to protect yourself. Is there any risk to quote unquote playing doctor?
Well, so you're right. You never want to play doctor on several levels, right? Because one, you might be misdiagnosing, and then two, you might be instilling fear in somebody who isn't sick that they are, and vice versa, someone who is sick that they're not. But, and I'm not necessarily advocating that you take the temperature of everyone who walks in, but in these times, a lot of employers are asking that question. Can I take the temperature? And the answer is actually yes, as long as COVID remains a direct threat to the public, which it does, and it looks like it will for the foreseeable future until there's a vaccine for it. Yeah, you can do things that maybe ordinarily you wouldn't be able to do, right? You wouldn't be able to do. So as far as not playing doctor, I'm not suggesting you play doctor, but what you can do is, let's say you said, I'm going to take the temperature of everyone who walks in, and somebody has temperature. Well, I would send them home, right? Well, are you suggesting that they have COVID-19? No, I'm not suggesting that. I'm not suggesting they have it or not, right? I'm suggesting that that's a symptom, and given that COVID is a direct threat, you're going home, and you'll be well within your rights to do that. So, while you're not going to diagnose people, if people are showing the symptoms and signs that are consistent with the disease, yeah, you have quite a bit of flexibility in how you're going to handle things.
Do you have to be selective? Can you selectively take temperatures, or is it like drug testing where it's all or none?
You could take the temperature of anybody who you believe might have cause exposure to other people in the workplace, that might cause a safety issue to people in the workplace. So that might mean that you're doing it selectively. It might mean that you're doing it to everybody. If you, for example, if you spot check people, okay, well, then you're spot checking. There's nothing wrong with that. If you know that you took the temperature or, made some inquiries of persons A, B, and C already, well, you don't have to ask A, B, and C again before you ask D. So everything has to be reasonable, and generally speaking, I would operate it in a way that is consistent, right? Consistent to avoid at least the appearance that you're picking on someone. But that said, spot checking is allowed. You don't have to take the temperature or make the inquiry of everyone, and you can use your reasonable judgment in doing that.
I had a question to this point about not announcing the name of somebody that has identified themselves as they have COVID-19. Yeah. And it seems very similar to if somebody's been impacted by a layoff or something like that, you don't usually volunteer that. But I found it's a good practice to ask the employee how they want it to be communicated out, because oftentimes they want that to happen. And if they give you permission, at that point, are you able to communicate that out and follow their wishes?
Well, consent is always going to be an exception to any privacy rule, right? Virtually all privacy rules can be circumvented if the person gives affirmative voluntary consent. I think that the issue that you might run into is, depending on the circumstance and the totality of the circumstances, is the person going to feel like he or she is being forced, right? Or coerced into giving permission to announce the name to the balance of the employees. That's going to be an issue, right? If you're a plaintiff's lawyer 6 months, a year from now, and so on, and you're trying to drum up business, which I hate thinking about, and I'm not a big fan of plaintiff's lawyers, but if you are, well, one of the things I'm sure that will be asked is, were you, what are they using? What's the term in the news now? Unmasked, right? Were you unmasked? Were you identified? And if so, why? And if the person turns around and says, well, I felt like if I didn't give my permission, they were going to fire me. They sort of kind of told me that I have to, and you're going to have a problem. So if it were me, unless there is a reason to announce that name, I would probably refrain from even asking permission. And to the extent that the person worked among others, right? Let's say Joe worked among Tom, Mary, and Jane side by side, and Joe comes down with COVID. Well, you're not going to tell Tom, Mary, and Jane that Joe has COVID. You're not going to, but you can say that somebody in this area was diagnosed with COVID, please quarantine yourself. Well, who is it? Doesn't matter who it is. Someone did. Now, they might turn around and say, gee, Joe's the only one who's not here. I guess it was Joe. But that's for them to do. As an employer, you don't do that. Let them do that. That's the way you're going to handle it.
It's great.
Excellent. Thank you. All right, let's just jump back over into we have a lot of questions to still run through. Let's see what we can tackle next. Let's jump a little bit into contracts and contract renewals. I'll just bring it over for you, Brett, that way that you
Sure. That's all right. I have my glasses here just in case. That's all right.
I'll ask anyway, so that you don't have to read if you don't want to.
When we first met, Jameson, I didn't need these glasses. I'm just saying. Same with you, Brett. I didn't need them.
2 years into glasses. They're new to me, but I just don't put them on.
We first met, I had hair.
Are there any
Stop
changes?
right there.
Yeah. Are there any changes I should be incorporating into new contracts or contract renewals? Like back to business,
Right,
is there
sure.
something I'm doing differently?
Sure. Well, any changes? I guess that assumes that you have a contract, right? Or that you have a decent contract, or that your contract is one that I would turn around and say, all right, this is a good solid contract. And now let's see what you can incorporate into it. What I think that this has told us, this pandemic has taught the industry, is that you really have to pay attention to service levels and to what you're promising, okay? And, no matter what, always make it subject to technician availability. I think that MSPs, in their zeal to get jobs in the door, to get contracts signed, will often overpromise, right? They'll talk about resolution times. I'm not sure how you could think of a resolution time until you know what the problem is. And I've seen contracts where it says resolution time for a priority 1 problem, 4 hours. How do you promise 4 hours on a priority 1 until you know what the deal is, what remains, what you have to work with? But I digress. Service levels are something that you really need to think about in light of this type of thing. Scope, right? The scope needs to be addressed as well, because what you understand that as we have distributed workforces, and I think that distributed workforce is here to stay, even post-pandemic, it's here to stay. I don't think everyone who was in a central location is going back to that location. I think a lot are going to stay distributed. So bear in mind that a lot of your contracts and a lot of your statements of work were written in contemplation of a central work location, right? Not necessarily in a distributed workforce, not using remote locations, not using personal computers and so forth. So I think that the changes to your contract don't necessarily need to address the legalities, because legalities haven't changed much since this pandemic. But what's changed? Realities. And if you've heard me speak before, this is sort of my mantra. An MSA has to not only address legality, it has to address realities, right? The reality of an expanded workforce, geographically expanded locations, scope creep, service levels, those are realities. So those are the areas you need to focus on.
So Brad, tying into that, obviously your privacy confidentiality agreements expanding to potentially a workforce that's working from home on maybe not company-owned equipment. How would you address that?
Well, so, and I've written an article about this on it was on LinkedIn, as a matter of fact. It's while your employees are working from home, as they move to remote locations and as you move them to remote locations, one of the things that companies are not thinking about, but they should, is the confidentiality aspect. Not just simply making sure that the connections are secure, that you're using a VPN or whatever technology you want to use, but making it understood to the employees what is confidential. What is confidential? Because I could give you, for example, the most secure connection, right? With the most, up-to-date software and the best VPN with all kinds of passwords and so on. And you go and you take it to a Starbucks and you go pick up your latte and leave your screen open. Good luck, right? You have the best technology, and anyone who just looks at your computer now sees everything. So I think that from a confidentiality perspective, not only is it important to fulfill your obligations by contract, right, that you're bound to do, but it's important to remind your employees about what is confidential, right? Our employees' information, our clients' information, our customers' stuff, that's confidential. The stuff you're doing for them, that's confidential. Don't use your personal email address. If you're having a problem with the computer, call us. Don't just assume you're going to, exercise self-help. These are the kinds of things that the employees need to be reminded about, and everyone on this, listening to this webinar should do that. I suggest doing it in writing, not necessarily a formal agreement, but I suggest giving all of your employees a document that says, reminding you as you go home, as you go remote, as you're doing these things, the following is information that is completely confidential. Boom, 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 boom. As a result, only use company equipment when you're doing company business. Don't use your personal email. Don't leave the screen open. Set screen savers for a minute or less or whatever it is. So if you do walk away, the screen blanks out. These are the things you need to do from an employer perspective, both in the middle of this pandemic and as we come out of it. Because again, I don't believe that as we come out of it, everyone's returning back to the office. I think a lot of people are going to stay home or stay remote.
And so, Brad, something specific to the pandemic, I'm seeing a lot of discussions around force majeure and including pandemic language in the contract. What's your perspective on that?
Oh, my perspective on pandemics and force majeures. I could tell you this, that generally speaking, a pandemic is not a force majeure. And anyone who says, oh, no, it's a pandemic, it's a force majeure, has no idea either what a force majeure is or simply hasn't done the research. A force majeure, okay, just so we all understand and we're on the same page, a force majeure is an event or an occurrence that makes it reasonably impossible, not impracticable, not economically disadvantageous, not difficult. A force majeure is a reasonable impossibility. A pandemic is not a reasonable impossibility in most cases. For example, I'm talking to you right now from Fort Lauderdale, okay? So if you were my MSP and I was your client and I had an issue, and I could tell you in my office right now, there's no one here that has COVID and so on. Well, we're still nervous, but that's not a force majeure. That's you being nervous, okay? What would be a force majeure? When would a pandemic be a force majeure? A pandemic is not. The results of it could cause a force majeure. For example, if the local regulation said no one is allowed to come into this area of Fort Lauderdale or leave unless you live here, right? Unless you live here or you're medical personnel. Well, now you have created a reasonable impossibility, right? Because even if you were nervous, but you'd say, I'll take the risk, even if you have PPE, you can't do it. If that's the case, then the pandemic has caused a force majeure. But generally speaking, force majeures are not, pandemics are not force majeures. So how do you address that in your contract? Don't rely on it in the force majeure section. Instead, if you want to put something in your contract, one of the realities, right? Realities, remember I talked about that earlier. One of the realities you should be thinking about is whether you can be forced to do something that puts your employees at risk, right? Or in reasonable risk, or we could probably be more artful in the contract, but the idea is you want to avoid putting your employees in situations that make them reasonably uncomfortable or reasonably at risk. And if those situations occur, have built-in delay periods, built-in suspension periods. That makes more sense than saying it's a force majeure, because it's not.
Excellent. Captured a lot on that question. That's great.
Yeah, we went. That's force majeure is one of those things. And if you Google it, you see a lot of people just even quote experts saying, "Oh no, this is a force majeure situation," and they're simply wrong. Simply wrong. The case law is very, very clear on this point. A downturn or a difficulty is not a force majeure situation. An impossibility is.
So I'm going to grab another question here. How are you influencing your customers and clients to behave in a safe way while in your establishment? So it's kind of a little bit goes back to, it's a little different. The I'm not wearing a mask and you can't make me crowd.
I'm not wearing a mask. You can't make me. That's good. So, how can you influence your customers or clients to behave in a safe way? I don't think you can, depending on what your MSA says, right? Again, if your MSA deals with the reality of you're not going to do anything or ask us to do anything that puts us in a reasonable risk or in our judgment puts us at risk, even more broad, gives you more rights, well, then you can rely on that and say, well, if you're not going to wear a mask, I'm not showing up. Other than that, if they don't wear a mask, I would suggest you wear your PPE and hope for the best, because you're not going to be able to just point to a point in the contract to get out of it.
Yeah, that makes a lot of sense.
And so I already moved this over because this is kind of a good segue to this next question.
Yeah, how do you handle an employee's refusal to wear PPE? Well, first of all, if an employee refuses to utilize PPE if they have a pre-existing condition, then they're probably too stupid to work for you. Yes, I said that. So, that's another story. Yeah, that's a different issue. Understand this, that as an employer, you don't have to assume that your employee has a pre-existing condition. You don't have to guess. You don't even have to ask. Okay? Your employee has to bring that to your attention. Once you are made aware of it, that's a different story. But also, your employee has to ask for the accommodation. Just because your employee doesn't think that he or she needs it, and I'm sorry, if your employee doesn't think he or she needs an accommodation, doesn't ask for an accommodation, well, you're not required to impose that accommodation on the employee. Okay, so keep that in mind. Personally, I would think that if an employee refuses to wear PPE if they have a pre-existing condition, I would absolutely make it a work requirement. It's the way it is. There's no law, there's no regulation that says that an employer cannot force its people to wear PPE. You could force your employees to wear masks and gloves and so on. And again, if somebody has a disability that requires an accommodation, like for example, let's say we're all in a company and I know Brett has doesn't want to wear PPE. Okay. I could say everyone here is now wearing face masks and gloves, right? That's it. You have to wear face masks and gloves. That's now a policy. Brett turns around and says, I have an allergy to latex. Can't wear gloves. All right. Well, then you're going to wear non-latex gloves, but you're going to wear gloves. See, we can make an accommodation but the rule is the rule. And if you can't follow my rule, then you're out. And that's the way it goes. So long-winded way of saying if an employer refuses to, force them to. If they don't want to, you have a decision to make, and my decision would be have them work for your competitor.
That's great. We have another question, and Deanna, I'm going to ask you to come in and ask it live. If you just click so if you unmute your microphone, there you go.
Hi, how are you? Hi, Brad.
Hi. Hey, Dina, how are you?
I'm awesome.
You're not far away from me.
I am not. Just quick question. So does everybody, if we come back to work and some people do not wear their mask at their desk, yet wear it at the common area, and we have everybody spaced out in their own office with their own door, but I have somebody saying, well, I don't want to come back to work because everybody's not wearing their mask at all times.
Right.
Is that a situation?
Wow. So that's good. Leave it to you, Dina, to ask those tough, penetrating questions that make us think twice. All right. So to reframe the question, make sure I got it. You have your employees back at work. You have social distancing in place. You have them wearing masks, gloves, whatever it is, in common areas where social distancing cannot occur reasonably, right? But some people don't want to wear masks when they sit at their desks, but their desks are in different locations. Like you said, they may or may not even have doors, right? Separating them from everyone else. They're in separate locations. They are more than 6 feet apart. You know, the question is, can you force somebody to wear a mask? Right. Well,
No,
first
the question is if the other person says, well, I don't want to come to work because everybody's not wearing a mask at all times. Do I have the right to say, no, you got to come to work?
of course, assuming that there's social distancing, right? Again, you can't put an employee in a position where there is a substantial risk to the health of that employee. But, you know, if the employee, especially if the employee itself or herself or himself is wearing a mask, and the person who isn't wearing a mask is distant in his own office, her own office, and so forth, well, I don't think that there's any justification for that person to say, someone all the way down there is not wearing a mask. I don't want to be in this general area. No, that's not reasonable. It's not reasonable. And I don't think that that employee has the right to not come to work and use that as an excuse to stay home or work from home and so forth. Now, different, my opinion might change if you said, well, we're all working in cubicles, okay? And while the cubicles, if you actually, you know, as the crow flies, looking at it from the top down, you're not necessarily 6 feet away from someone, but they are high walls, so you're sort of in your cubicle. You can't even. I'm not convinced. I'm not sure that that would be. I think the employee might have a position, a good argument there. But if you're, you know, social distancing, the CDC recommends 6 feet or more away, then you're going with what the recommendations are. I'm not sure that the employee has grounds to do or say what he or she wants to do.
All right, thanks.
Sure. Tell Jason I said hi.
I will.
Perfect. Thank you.
Go on to that one too, because in the news, in the medical community, there's a lot of question about ventilation as people are.
But you know, that's usually I've seen a lot of those questions about ventilation, more about in things like planes, right? Where it's just recirculated and everyone is in close proximity. So even if it wasn't recirculated, you go like this, you're going to hit someone in the face. I have not yet seen that kind of a discussion or those kind of restrictions in a workplace facility where people are farther than 6 feet apart, right? And even especially when they're in closed spaces, like their own office with the door shut. I don't think you're going to argue, well, the ventilation, it could pull from the intake and circulate through. I haven't seen anyone take that stance yet.
Interesting. Any other questions from the coaches before I move on? All right, we still have several more here. Yeah, this is pretty relevant, I think. How are you affected by applicable laws before requesting employees' medical information?
How are you affected by, wait, I missed that question. There you go. By applicable laws before requesting an employee's medical information. All right, so there is a difference under normal circumstances about what you can ask an employee about his or her medical conditions. There's a difference between pre-COVID and a pandemic. When we are in the middle of a pandemic, we are in the middle of what we call a direct threat. That's actually the buzzword, direct threat. There's a direct threat to the health of your employees, of you, of people around in your workplace, and so forth. When there is a direct threat, the rules are altered a little bit. You have a lot more leeway to ask a lot more stuff than you would ordinarily do, right? Ordinarily, you might not be able to take the temperature of people walking in. When there's a direct threat, there is. Ordinarily, you may not be able to ask somebody about what symptoms are they feeling? Are they feeling okay? Do you have any family members that are ill? And so on. But when there's a direct threat, you can. So you know, you have to, I think, take these questions and take this, what we're talking about now, in the framework of we're operating under a direct threat. So when you're operating under a direct threat, you can ask a lot of questions. Are you sick? Right? Can I take I'm taking your temperature, you know, let me see your forehead. You can do things like that. As far as privacy is concerned, all of that remains private, right? It all remains private. It all remains under HIPAA, that person's private information. But whereas in the past you might not have even been able to approach it, now you can ask, but you have to take the answers and treat them privately, which means you can't tell people what the results are. You know, you can't announce, like I said earlier, Joe has COVID. Can't do that. While you have leeway to research for the reasonable purpose of protecting others in the workplace, you still have to keep things confidential.
So one thing that's kind of interesting, I have a friend who owns a facility. He's having people come in, they're doing temperature on the forehead thing. It's right at the entrance of the facility.
Yeah.
Like, if your temp's 102 and you're not going to let that person in, is it there? I mean, where's the privacy in that? You're at a populated entrance. I mean, they're doing it at Costco, I think. Like, if you know what I mean? Like,
Sure.
How do they maintain that confidentiality in those public situations?
Sure. Well, you know, I'll tell you this. Medical records have to remain confidential, right? Everyone has to keep things confidential and everyone has to act reasonably. That said, HIPAA doesn't require 100% perfect confidentiality. You know, if you go into a doctor's office, for example, right? Now there are physical, under HIPAA and high tech, now there are physical requirements, physical layout requirements of, you know, where people can be, as opposed to where the receptionist might be who's asking the incoming patient about why he or she is there and so on. But you may have noticed that even after HIPAA was implemented, receptionists can still, you know, face waiting rooms and people can still be in waiting rooms, and maybe we've distanced people, right? We've moved the seats farther back and so on. But if, you know, for the inquisitive, you could still hear what's going on. You could still see what's going on. It doesn't require perfect confidentiality. And I would suggest that that is the same with taking the temperature. While I am unaware of any regulation or opinion from Health and Human Services or any other regulatory entity that says when you are testing people, that has to be done in a confidential manner. I think that we have some guidance, right? First of all, you could use the guidance of reasonable spacing, which is required under HIPAA. I think that you can keep the results, reveal the results to somebody in an area where they are not around other people. So if they do have to go home, you know, they're not sitting there in front of everybody going, "You're kidding me, I have to go home now?" I mean, you know, tell them in a different area. And I think that even if you look at how testing is being done right now, I mean, you know, people are waiting online and they see what's going on. Maybe they don't learn the results right then and there, but it doesn't require perfect confidentiality. It requires reasonable confidentiality. So keep that in mind as you're figuring out physical formatting and layouts of how you're going to do things.
Thank you. Yeah. All right, about 10 minutes left. If anybody has any questions, use the Q&A, but we've got a few more queued up here. Brad, what is my liability if I have an employee not taking adequate precautions in the field and a client claims they were infected by my staff?
Wow, that is a lot of leap of faith, right? That is a lot of mental steps to get to where, you know, where that customer would be. I mean, first of all, you have to have an employee that's not taking, quote, adequate precautions. And I would say that even the minimum precautions, a mask, gloves, that's adequate at this point. But let's assume they're not, quote, taking those. And then the client says that they were infected by the staff. So it means that your staff had to be infected, right? The client had to be infected, and the client is going to be able to prove that the infection came from your staff, as opposed to going to the supermarket, as opposed to going to Walmart, as opposed to taking a walk and shaking hands with somebody. that is one of those, I think, more law school exam questions, right? Right. Tell us the issues. Tell us all the various things that you see in this question. Realistically, I cannot see, God, I hope we don't see, but I can't see it right now. Causes of action, real cases coming about saying, I can link my disease to the misbehavior of your staff member. Even if your staff member did misbehave and didn't wear the mask, how do you link it to that person? I mean, that would be a tough case to prove. Maybe someone's going to go for it. Generally speaking, I don't see it happening.
You know, I have seen that there's been discussions on changing some of the laws to prevent some of the class action style lawsuits coming from these types of scenarios, I guess.
To avoid exactly that, right? And then what happens is you have a plaintiff's lawyer that takes it on contingency, sues a big company, and then just sits and waits until the company says, all right, we're going to settle. So yeah, that's a tough case to prove. Very tough.
Okay, great. FMLA, want to talk about FMLA?
I see the question. Does it apply to me if I'm only 10? Yeah, it was expanded to everybody. It's expanded to all companies. Used to be 50 or more, now it's 50 or less. So the quick answer to that is yes. Does it apply? Yes, it does. At least through the end of the year.
Okay, so through the end of the year at this point.
Right.
Okay, great.
Moving on.
I think did we answer this one already?
We did, but it bears repeating. If somebody is diagnosed or has COVID-19, is out, even if they're asymptomatic, but they're diagnosed with it, can you require a doctor's note before allowing them to return to the office? Oh, yes. Not only, you can require a doctor's note as long as it's a direct threat. Someone who's diagnosed with it now becomes, unfortunately, a direct threat, and you can absolutely require a doctor's note before that person comes back. You could even, here's a sort of an extrapolation of that question. If you extend an offer to a job applicant, and then it turns out that applicant has COVID-19, you could delay the start date. You could push that back until you get a doctor's note that says they are fit to serve. Absolutely.
Okay, great. I think, let me see if we have one more question. While Brett's scribing there, we had one more queued question. If there's anybody else who has questions or anything else Brad wants to add, by all means. I'll drag this one. Privacy laws, we kind of hit, I think, on most of the privacy.
Yeah, I think we have. Yeah, I mean, there aren't a whole lot of, the privacy laws now relate to like HIPAA, high tech, and so forth. And I guess the message that we're trying to send here is that even though that you have an expanded right as an employer to do due diligence into an employee's health, right, a little bit more, take temperature, ask questions, and so forth, you still have to treat everything as private. This has not expanded your ability to disclose that information. It still has to be treated as confidential. Personal health information can only be disclosed as per statute.
Excellent.
So I'll add one last question here. You know, with states all being a little bit different in terms of how they're opening up and how they're handling these, do you see any particular areas that are more problematic? Is it better just to work with your local attorney on understanding that? What would you advise people to do?
Well, I think that, as states open up, they are removing the essential worker versus non-essential worker. The difference, the lines are becoming dissolved. And now people are just saying, look, whether you're an essential worker or not, you're allowed back, and so on. I think that you need to make sure before you start requiring your people to come back that there's no regulation, local regulation that says you're not supposed to be doing that. Different states are doing it differently, right? I mean, states like Georgia and Florida actually are a little bit farther ahead of the curve in opening up than places like New York or New York City specifically.
But to that end, even like Texas, for instance, has guidance from the governor, but some of the local county judges here are actually imposing different conflicting stay-at-home restrictions. And so any of your local laws is, or restrictions or guidelines would be important.
Well, judges shouldn't be doing that. I think,
County
you know,
judge.
local county commissioners and so forth, they can make
That's
decisions.
what they call them here, yeah, is a county judge, but it's.
Oh, okay. All right. It's like, I don't have a case in front of me, but everyone should stay home. And that's what I've decided. It's like, wow, that is some judge. That is some
Like
powerful stuff that you have right there. Yeah, so I would definitely check to see if there are any local regulations that prevent you from acting in a way that you see the rest of the country acting, for sure. Most definitely.
Great.
So we have just a couple minutes left. If anybody has another question they want to queue up, or any of the coaches have anything that they want to add. Have any other questions popping up? Brad, anything you kind of wanted that, anything that we kind of missed? I mean, of course, there's a million things missed. We probably talked.
I think that, you know, I think that from a health perspective, I think we've pretty much covered the, you know, all of the issues. I think from a business contract perspective, one of the things that everyone has to keep in mind, or at least it's my prediction, that business is going to pick up. I have found personally in representing all these MSPs that business has stayed at least stable for the most part. Yes, there are MSPs that have experienced downturns and so on, but a lot of them have actually picked up business. I have found that it's pretty much remained stable. But as the world goes into a post-pandemic mode, I think that what we're going to see is companies rely more on MSPs. Companies that have never relied on them before are now going to start to use them, right? They give economies of scale, they give better security, they can implement the technologies that we now all know and use, like this, Zoom, which has been around for a while, but not used the same way, not to the same extent. And there are more features every day, right, being added. And who does that better? Who does that better than a service provider? No one. So they're going to look to service providers. And along those lines, if you haven't done your contracts, if they're not in good shape, if they're not, you know, if you're not totally sure about what's covered and what isn't, then you need to have those reviewed, right? You need to have those reviewed. If you don't have those reviewed, you know, if you're going to wait until the business comes, that's too late, because then you're under the gun. So, you know, one of the things that I talked to you guys earlier about is, if anyone who's listening to this webcast wants us to review their documents, we will do a free consult. They just have to send us an email to info@bradleygross.com. It's info at bradleygross.com. Make sure that they have the name of this webcast in there, an extra, and we will call you back and arrange a consult to discuss. But that's something that I think every MSP really needs to be thinking about. In a post-pandemic world, you're going to be used more, not less. So make sure you're ready, not just from an infrastructure perspective, but from a contract perspective as well.
We had just, and I think we have time for it. We had one more question come in. I'm going to ask you to respond to. Paste it in here and everybody can see. Oops, that didn't work. Maybe somebody else can do it. So the question is, let me see. Oh, where'd my chat go? There it is. In New Jersey, they say if your business is not a retail business, you can continue to operate, but you must let your workers work from home whenever possible. Does that mean we can't bring them back into the office?
Well, again, I think that we have to look to the local regulation. And while I'm not familiar with a local regulation in Jersey that says that, I would say that if the regulation says that non-essential people still have to work from home, you follow the regulation. I would say, without having seen the statute, obviously, or the specific regulation that they're talking about, that IT professionals very often are fit under the category of essential personnel. So that's something to think about. You know, most of the people on listening to this webinar could probably justify being called essential personnel. So that's, you know, a consideration before you just assume that, oh, everyone can work from home and they have to work from home because that's what the regulation says.
Perfect. Thank you. Any last questions or comments from any of our strategic coaches or from Brad before we wrap?
I was going to throw a hornet's nest out there, but let's assume that a vaccine is released. You absolutely cannot force people to get that vaccine. Is that correct?
Wow. Is that, are we ending this right now, this webinar? Is it, can you force people to get a vaccine? No, you can't force anyone to get a vaccine the same way that you can't force them to. I mean, you know, you have a lot of, it is not my personal belief. In fact, it is my visceral reaction that you should get vaccinated, right? I think you must get vaccinated, but there are people out there that don't believe they need to or want to. You don't have the right to require somebody to get vaccinated in their life, but if they pose a direct threat, or for some reason, if the vaccine works and you know, it's not a complete solution and so on, you might say, I require it as part of my workplace. As part of this job, I require you to have these vaccines. If you don't have it, go work for someone else. That's the way it is. I mean, you know, I think that we'll deal with that bridge when we cross it. But I have seen a lot of workplaces require things of people that they couldn't force them to do in real life. But if they want to work for me, that's what they have to do, right? If you want to work for me, you have to dye your hair red. I'm not saying I can't force you to, right? If we are in everyday life, but if you want to work for me, I require all my people to dye their hair red. I do. That's how it is. So I think that that's probably an enforceable workplace rule, but we'll see. We'll see when the vaccine comes out in a year, hopefully less from now.
Perfect. Well, thank you. We're right bumping up against the end of our time. One thing I just wanted to, we'll post-assess here, but I would love to point out that we started with a handful of questions and issues, and thank you to Brett. You can see that he has scribed the heck out of all of Brad's answers. So we have the recording on Facebook Live. We will also post it on our website. If you want to connect with Brad, he gave you his email address. You can also see on his high-tech green screen right behind him.
My high-tech green screen. This is old school. This is old school. This is actually a curtain.
www.bradleygross.com or info@bradleygross.com to connect with him, or just reach out to us and we'll connect you either way. If you need any assistance around thinking about strategy as we move through this pandemic, one thing we all talk to our clients about is, you know, wealth is built and lost in times of economic upheaval. We are finding that our clients that are doubling down on strategy instead of forgetting about it during these times, they're going to come out of this and are already starting to come out of this much stronger than they entered it. This is kind of where the differentiation begins. So we'd love to have a conversation with you. Check us out at connectstrat.com or shoot us an email. Also info@. And thanks everybody. Brad, thank you very much for joining us. Super informative. And until next time.
Thank you, Brad.
Thanks, guys.
Good to be here. Thanks, guys.
Thank you.